The police arrived at my door at 11:20 on a Tuesday night and arrested me on the basis of a phone call my partner had made from the bathroom while I was putting our children to bed. I am going to tell you this story forensically, which is the only way I know how to tell it now, because forensic precision is what saved me, and it is the only register in which I can speak about what happened without the telling of it costing me more than I can afford. My partner and I had been together for 7 years. I will call him Marcus. Marcus had, over the preceding 18 months, been engaged in a pattern of behaviour that I now understand, with the benefit of professional support and a great deal of reading, as a specific and documented form of psychological control. At the time, I understood it as something being wrong in our relationship that I was failing to fix. The difference between those two framings is significant. The first framing has a name and a legal recognition. The second framing keeps you in the house trying harder. On the night of the arrest, we had argued. I want to be precise about the nature of the argument because the precision is the point. It was a verbal argument. There was no physical contact. I raised my voice. He did not. He went to the bathroom. 15 minutes later, the police arrived. He had called them and told them I had been physically violent. I was taken to the custody suite. My children, aged 4 and 7, were left with Marcus. I was interviewed, bailed, and subject to conditions that prevented me from returning to the family home. I was separated from my 4-year-old and my 7-year-old for 6 months, while the family court processed a safeguarding concern that had been generated by a phone call I had not made, describing an incident that had not occurred. 6 months. My 4-year-old's birthday happened during those 6 months. I was not there. I want to stop at 2 minutes and be precise about something, because the precision matters enormously. When a domestic incident is called in, the police are required to follow a risk assessment protocol. The protocol requires them, among other things, to canvass neighbours for any relevant information. Canvassing neighbours is not optional, it is in the protocol. The neighbour directly across the road from our house had a doorbell camera that covered the street and our front path. She had had it installed after a car break-in the previous summer. It was motion activated and recorded continuously. On the night of the arrest, it had recorded the police arriving, the door being answered, and the preceding 30 minutes of street activity. No officer knocked on her door that night. No officer knocked on her door during the subsequent investigation. Nobody from the police, the Crown Prosecution Service, or the family court asked whether any neighbour had any relevant information. The camera had been there all along, directly opposite our house, recording. My solicitor is a woman called Claire, family law and criminal specialist, with the particular economy of language of someone who has been asked to rescue cases that should not have needed rescuing. Claire told me in our first meeting that the key to my situation was establishing as quickly as possible what the independent evidence actually showed. She said there is always independent evidence. The question is whether anyone has looked for it. She asked me to think about who or what might have been watching that night. I remembered the camera across the street because I had waved at it once, absently, in the way you wave at things that watch you in your own street without quite acknowledging that they are watching you. I told Claire. She contacted the neighbour, a woman called Sandra, retired, precise, not particularly interested in being involved, but willing to help if asked, and Sandra confirmed the camera existed, that it had been recording that night, and that nobody had ever contacted her about it. The footage showed Marcus going upstairs at approximately 10:55. It showed the police arriving at 11:20. In the 25 minutes between those events, it showed me coming to the front door 3 times, once to take out a recycling bag, once to call the cat in, once simply standing in the doorway for approximately 90 seconds in the way of someone who needed air after an argument. At no point in those 25 minutes was there any indication of a physical altercation. There was no one running, no raised voices audible from the street, no movement consistent with what Marcus had described to the police. Sandra's footage was 25 minutes of ordinary. Ordinary is, it turns out, extremely powerful evidence when it contradicts an account of extraordinary violence. The midpoint arrived when Marcus's solicitor received Claire's position statement, which included a summary of Sandra's footage and a formal note that the footage had not been requested by the police during their investigation, despite the neighbour's camera being visible from the street. Marcus's solicitor filed a counterclaim 3 days later, alleging that I had orchestrated the footage and coached Sandra. He also filed a non-molestation application in the family court, alleging an ongoing pattern of abuse. A counterclaim against a woman who had been on the doorbell footage taking the recycling out. Claire described the counterclaim as precisely the kind of escalation that a pattern of controlling behaviour produces when it is challenged, an attempt to flood the system with enough competing claims that the original picture becomes unnavigable. She said this is what it looks like when someone who has been controlling a narrative loses control of it. The non-molestation application was heard in November. The footage was central. Sandra gave evidence. She was 67 years old and had the particular quality of a retired professional who understands that the details matter and who communicates them with a precision that is very difficult to shake. Marcus's barrister attempted to suggest that the camera angle could not definitively establish what was happening inside the house. Sandra agreed that it could not. She said, but it does definitively establish that at no point in the 25 minutes before the police arrived did anyone leave that house in distress, seek help from a neighbour, or attempt to contact anyone. She said this quietly and without drama, and it was, in my view, the most important sentence spoken in that room. The non-molestation application was dismissed. The counterclaim was dropped. The criminal charges had already been discontinued 2 months earlier when the CPS reviewed the evidence. The settlement was reached in January. Marcus and I separated formally. The children came home to me. The arrangement now is shared care, which is its own complicated story that I am still inside and not yet ready to tell. The costly part, the 6 months. Not metaphorically, literally. My 4-year-old calls Marcus daddy and calls me mummy, and does not understand why there was a period when mummy was not there, and has stopped asking about it in the way that children stop asking about things they have decided are too complicated or too sad. She is 5 now. The birthday I missed she will not remember. I will always remember it. And Sandra, who had a camera across the road and who nobody asked about for 6 months, keeps the footage backed up on a hard drive. She told me she does not know when she will delete it. I told her she does not have to.